Welcome, my name is Emmanuel from MGM Abogados Consultores, attorney at law based out of Santiago, Dominican Republic. Our social media platforms are Instagram, Facebook, and YouTube at MGM Abogados Consultores, the way it appears on your screen. And today I'm going to continue talking about a topic I posted this week on Instagram. The topic is the notifications that the petitioner might receive from the USCIS director before he actually approves the petition. Now, upon submitting the petition, the USCIS director is going to check the documentation to see if the beneficiary actually qualifies for the immigrant visa which he or she is seeking. If the USCIS director doesn't approve the petition right away, he might send out a few notifications allowing the petitioner to submit additional documentation. The reason I say he might send out a notification because as of July 2018, USCIS issued a memorandum saying that the USCIS director has no obligation in sending the notification. It's upon his discretion to deny these petitions and tell the petitioner if he's actually interested in the beneficiary receiving an immigrant visa to submit a new petition. Let's talk about 4 of the notifications that the petitioner may receive. One of them is the request for evidence, the other one is the notice of intent to deny, notice of intent to revoke, and the last one is titled the decision. Now, the notice of, the request for evidence is the first notice we're going to talk about. This is where the USCIS director is going to actually tell the petitioner which of the documents is going to establish that the beneficiary actually qualifies for the immigrant visa that he is seeking. This is the easiest out of the notice to overcome, and the easiest for the petitioner to submit documents to, because in the notice itself is going to tell him what documents he or she is going to need. Now, when we talk about the notice of intent to deny, the USCIS director is acting upon past immigration history. Now, this could be from the petitioner or the beneficiary, in the sense where these people have had previous immigration history, and this is the basis upon the notification. For example, I have one of these notifications here on my desk, and this one specifically is about the petitioner. The petitioner in this case was a beneficiary in 2011, and after he already received his green card, got divorced from the spouse that petitioned him, and submitted a new petition for somebody else. And because of this past history with immigration, like I stated before, is the reason why he received his notification. These are one of the cases I actually took care of in my office, where we received a notice of approval after we sent in all the documentation establishing that his previous marriage as well as his current marriage is actually legitimate and not trying to evade immigration laws. Now, the notice of intent to revoke, this is really based on a dual interview made by the consular officer to the couple. Now, the consular officer, what he's going to do is, if he feels like the marriage is a sham or isn't legit, he's going to temporarily deny the immigrant visa to the beneficiary, send his findings back to the immigrant, to the USCIS director that actually approved this petition, tell him about his findings, and the USCIS director is going to issue a notice of intent to revoke, stating the facts in the notice and giving the petitioner a chance to send documentation to establish that the beneficiary actually is his spouse, not for immigration purposes, but because they actually want to continue life as a family in the United States. Now, the last notification received by the petitioner may be the decision, as it's titled. In this notification, the petitioner has already sent in evidence for the USCIS director to look at, to evaluate. The USCIS director feels like the documentation sent to the USCIS office does not overcome the grounds of denial. So what he's going to do is deny the petition, but he's still going to give you an opportunity to submit an appeal to the Board of Immigration of Appeals. This is one of the notifications that one client came to our office with, and here it establishes what documents already have been sent in And upon these documents is that you're going to appeal the decision made by the USCIS director. If you have received any of these notifications, you can get in contact with us via our social media platforms or our telephone numbers. The office number is 809-382-8867. The WhatsApp number or the mobile number is 829-983-7982. Thank you for your time, and we hope this was helpful for you guys.